number 182 in the matter of ACME Bus Corporation versus Orange County.
Good morning, Your Honors. May it please the Court, my name is Richard Hamburger. I represent the appellant, ACME Bus Corp. I'd like to reserve, with the Court's permission, 2 minutes for reply.
Not 2 hours, sir. Sure.
Not want 2 hours.
You're not getting this. You may have your 2 minutes, sir.
Thank you. There are 3 important issues presented by this case. The first is the deviation issue, the extent to which a municipality may ignore its evaluation criteria in RFP context. The second is whether a usage matrix is required so that the lowest cost could actually be determined in a definite and certain way that is transparent to all of the proposers. And the third is whether the education law or the general municipal law govern.
You asked permission to appeal on one issue, did you not?
I did, Your Honor.
Can we look at the other 2 then?
Yes, Your Honor, because orders are appealable. And once the court grants leave to appeal from an order, then any issue that's before the court.
It's been said that we look at those things and we decide whether to grant leave or not, depending on what the leave application is. And if someone then grants, says, oh, because you granted leave, can we discuss the death penalty, or can we talk about other issues that may have been in the case? I'm exaggerating on the death penalty, but for the fact that if those 2 had been asked, would our decision have been the same? Or perhaps we would have said, this is not a leave-worthy case.
Well, my understanding of the court's jurisdiction on this is that if the issue is preserved in the record, and all of these issues are preserved in the record, that they are reviewable by the court because the jurisdiction of the court is the appeal from an order, and the order brings up all of the reviewable issues that are preserved in the record. Okay. I don't believe there's any authority, certainly not clear authority, in Carger that says to the contrary. And I think that most lawyers would be well advised when they're making a leave application to the court to focus on the main issue. And the main issue, the most important issue, is the one that I moved for leave on and which the court granted leave on, which is a very, very significant issue.
What's the standard in your view?
The standard in my view is de novo. It's a legal issue.
No. I mean, you're criticizing the county for what it did.
Yes.
And what standard, in your view, should the county have used when they made this determination? Are you saying that they didn't have any discretion in this regard?
No, I think that where RFPs are concerned, municipalities do have discretion, and it's important that there are certain issues that are not in this case. For example, this is not about whether the specifications were particular enough. Here, we have very specific evaluation criteria. And the issue before the case is, if a municipality chooses in the RFP context to have specific evaluation criteria, can they review the submissions when they come in, and can they say, well, we don't care what our evaluation criteria were.
But that's not what happened here, right? They used their criteria. It's a 104 case. It's not a 103 case. They had a criteria. You disagree with their change, I guess it is, to the percentage they applied to cost differentials. And aren't we just looking at whether that's arbitrary or capricious and whether there's a rational basis for the way they did that?
Well, respectfully, Your Honor, it's arbitrary and capricious when government doesn't follow its own evaluation criteria.
Let's assume for a minute that this went your way. In other words, they're saying, we said these percentages, but they're not giving us the picture that we need. So we're going to revise them so they give us the picture that we need in terms of evaluating these bus companies.
Government can't do that.
Well, I suggest to you that it may be possible that we remember that RFPs are for the benefit of the public.
Correct.
For the benefit of the government, and not for the benefit of the bidders. And you always have bidders who say, well, you didn't do this or you didn't do that, and you don't have that kind of discretion. And that's why I asked you what the standard is. And if absent bad faith or something like that, aren't they, within limits, of course, able to do things like this?
No, Judge Pickett.
Wow.
Because the issue is arbitrary and capricious.
Well,
and it's arbitrary and capricious.
Isn't there part of that has to do with whether it's in violation of lawful procedure as well?
Well,
aren't you saying it's arbitrary and capricious because it's in violation of lawful procedure?
I would say it's arbitrary and capricious. It's irrational. It's in violation of lawful procedure.
What's the lawful procedure?
Lawful procedure is you follow the evaluation criteria.
But it's an RFP. And it's not a request for bids, it's an RFP, and you're asking us, as I read your briefs, to apply the standards for bidding. It's an RFP. and they deviated from the example they gave in the RFP. So what was unlawful about that?
What's unlawful is that they deviated from the evaluation criteria they had in the RFP. They said that they were going to have a 10% deduction, where for every 10% differential in price, they were going to take off 2 points, and they took off 2 points for every 4%.
Did they,
Because-
did they at any point retain the right to deviate?
No, no.
There's nothing on the RFP
No.
that says they may not choose the person who has in fact submitted the lowest bid?
No, no,
Did they ever notify you that they were changing their evaluation procedure
No.
before you submitted the bids?
no.
Did
We
they
only
ever
found out
notify, excuse me, did they ever notify you after receiving the bids that they were changing the evaluation procedure?
only after I brought an order to show cause, and in response to the order to show cause, we set up a briefing schedule in which they submitted a return that we could see the evaluator's documentation as to how they arrived at what they did. We
Counsel,
did
what
not know
does
that
this
beforehand.
language in the RFP mean? The county reserved the right to waive any informality, to reject any and all proposals, or to accept any proposal in whole or in part if deemed to be in the best interests of the county.
Well,
That's
there-
not a reservation of some sort of right.
Sure it is,
Yeah.
but there are several pieces in that. One, they can reject, and that's what they should have done.
Any and all.
Well, no, they could have done it by zone. That's another part of that reservation. There were 3 zones. They could have awarded 1 zone. They could have put another zone back out for procurement.
But the focus is, correct me about this, you're sitting there and you're trying to do the best thing for your county with special needs children, and you have this RFP, and you can't sometimes think of everything. You know, somebody says, I got better drivers, I've got, you know, I can do weekends, you know, and so you look at all of this and you try to evaluate it, and you're not saying, well, you know, ACME Bus gave us more money for our, you know, in our elections, and therefore, we're going to award it to them. There's no hint here of anything other than Orange County doing what it thought was in the best interest of its
Well,
taxpayers.
that's correct on this record, but also I wouldn't know. The point is that, as you said in Acme Roosevelt, same company, ironically, you said that there are 2 central purposes of the competitive bidding statutes. One is the protection of the public fisc, which Judge Piggott, I think you're discussing, where you want to get the best value for the public, and the other is the prevention of favoritism, improvidence, fraud, and corruption. And
No, I was
there's a
talking about
tension there.
RFPs. I wasn't talking about bidding. And I think, you know, there's a substantial difference in the two, because with RFPs, you're looking for much more specialized trade. If you got fungible goods, or if you got common services, it's easy to say, you know.
You can't do an RFP unless you fall into certain categories, and this falls into that category.
Right.
There's no dispute about that.
Counsel, once a county establishes criteria by which to guide the RFP process, is there anything that would allow them to deviate from that established, announced criteria?
They must follow the criteria in determining who the highest scoring proposer is. And if, when, upon review of all of the submissions, they're not happy with the results, for example, here, because the highest scoring proposer would have been the most expensive proposer, the law permits them to do it over.
But they weren't bound by the points, were they?
Yes, they were.
No, so they get 85, 86, and 84 as a total point score, let's say. Do they have to give it to the highest point winner?
Yes, that's my view, and the county,
So then you're saying that this provision that says the county reserves the right to accept other than the lowest price offer, that they could not retain that right?
they can't, in the language of, respectfully, may I finish my thought, Your
Yes,
Honor?
please.
They can't, respectfully, they can't, in their bid specifications, put in a statement which says, regardless of our criteria, regardless of how we've set this up, in the end, we can do whatever we want. And that's the county's position. The county's position is that they're not bound by awarding to the highest scoring proposer.
Suppose they didn't have this percentage business, and then they did exactly what they did anyway. Would you have a case?
Well, if they, that's the issue I said isn't in this case. I think it's a much harder issue where the county has more flexible, more generic, more ambiguous standards. That's a much harder issue.
So you're saying because they chose to advertise a standard that they perhaps were going to use anyway, because they put it on paper, even though they made a reservation, they're bound by it. But if they hadn't put it in the RFP and had done it, that's okay.
I'm saying that it was an open invitation for manipulation,
But there's no
fraud.
allegation of them. There's none of that.
That's not required.
And well, that's why are
I
you
mean,
saying
if I
it?
had that,
why are you saying it?
that would be a different case.
As I understand it, what they're saying is that the difference in the prices were such that we had to do something to vary them, and the 4% didn't do it, so we did the 2.
Well, that's exactly. They reviewed it, and they said the differences in the prices were so great that the formula didn't properly award an appropriate number of points, so we could give it to the low-cost proposer. So we gave it to the low-cost proposer anyway. I'm saying in RFPs, they have to follow the rules.
If you came and said to them, I understand, this is what you did, is, okay, never mind, we won't do that. And so they don't. And then they do the bidding, or they accept the proposal that they accepted anyway, then you would not have a case.
I'm sorry, respectfully, I didn't understand the question, Your Honor.
Well, you're saying they put it in the RFP, they followed, they changed it, and they awarded it, and that's wrong. So if they said, all right, we put it in the RFP, we won't use it.
Well, no, they have to use it because it's a criteria they put in the RFP. Under the education law,
But it's price. It's not like you're going to change your price depending on what this formula is.
Well, a proposer very well may change the price depending upon what the formula is. That's the point. That's why the rules should be transparent and it should be clear what the criteria are
I
beforehand.
mean, you may have
so that it's-
acted differently if you had known that whatever formula they now claim they actually used was the
Absolutely,
formula
Judge
that they
Rivera.
had announced. You might have
Absolutely.
come up with a different number.
Absolutely.
As a result.
Absolutely.
What
That's
would you have
what,
done?
well,
What would the number have been?
I think the expression is, my client may have sharpened his pencils in that
But you
situation.
wouldn't know what the other bids were, they were sealed. So how would you react to a difference in, you think, well, I must be 10% over this, or I might be 4?
Oh, no. There are many ways in which contractors, they look at the way the bid is structured. If this bid is structured where 20% goes to price and 80% goes to these other areas in which my client should have scored very, very heavily, experience, qualifications, references, financial stability, then he can be more aggressive on the price. If the price is going to be 50%
But they're
of
not
it,
talking about changing the percentage of what the cost is worth, they're just talking about how they rank within the 20 points.
they changed the formula. They said, this is how we're going to award points.
For the 20 points, for the cost, as I
Yes,
understand.
and my client got 6 points.
Right.
Excuse me,
But
8 points
It's
instead
not
of
like
getting
they
16
changed the
points.
entire formula as to that, what that block
They did change
was
the entire
worth.
formula, Judge
As to
Garcia.
that's what that block was worth. It was always worth 20 points.
Yes, but they awarded my
I
client,
understand. But I want to get back to one more thing, if I can. Your position is, if you had a score of 85 and another company had a score of 84, yet your price differential, you would have cost the county $2 million a year more, that they still would have had to give it to you because you scored an 85?
absolutely not. No court can compel them to give it to me. They don't have to give it to
But
me.
I thought you said that they had to give it to the highest point winner.
No, I say that they have to give it to the highest scoring proposer or do-over. They
Thank you,
always have the
counsel.
right to do over.
Thank you.
Always have the right to do over. Thank you, Your
Point
Honor.
they can always reject the bids.
They can always reject the bids
But you
and
can't reject the
restructure it.
bids if you're, for example, if you got transportation coming up in September and the bids come in July.
Of course they can. They extended this contract.
You
by
say
6
that, but-
No, the law says that. They extend- Sorry.
I'm saying, it's possible that, as a municipality, you got to do some things, and you've got to sign contracts, you got to pick out the routes, you got to know where the kids are, you got to do all of this stuff. So it may not be as easy as saying, we want a different crate of oranges.
They extended my client's contract by 60 days because in order for this process to go through, that was a provision in the contract. They could, under the county law, have extended it further on an emergency basis. They have a lot of power to do that. They have a lot of power to extend it. It wasn't that they had to come up with this right away or the children wouldn't have been transported.
Thank you, sir. Counsel?
May it please the court, my name is Carol Pierce. I'm from the Orange County Attorney's Office, representing the County of Orange and the Department of General Services.
Ms. Pierce, can the county establish criteria for determining the RFP, announce the criteria, and then during the deliberative process, change the criteria?
In this instance, we did not deviate from the criteria. In the RFP, there was a waiver provision that we could waive any informality. But in this instance, there was set criteria, and we did not waver from that criteria, contrary to ACME's belief.
So talk me through the cost category.
The cost category was supposed to be, the RFP had, for example, in there. It was going to be a 2 points per 10%. However, just to give the court a background, the evaluation committee does all of the other criteria and then opens up the cost proposals. So all the other points were done before that. When they opened it up, they realized that there was not 10% between VW and quality. They could not do that formula, and therefore came up with this 2 points to 4%.
So did they change the formula? So did they change the formula?
They changed the formula, but it was an example, and we could not use that formula. And I would say we gave
When you say you couldn't
notice,
use that formula, why couldn't you use that formula?
because there was not 10% between, in the zones, because there were 3 zones, there was not 10% between VW and quality that we wouldn't be able to differentiate. They would both get 20 points in one
I've
zone.
never seen the argument you're making that you can change your evaluation process after bids are submitted. I've never seen that. I was a councilman in the city of Buffalo for 13 years, seen many RFPs and many competitive bidding, and RFPs give you enormous flexibility, but not the flexibility to change the rules once you set them. I've never seen this. Can you point to me an instance where this has happened?
Well, I can't point to an incidence that this has happened because, as this court knows, there's not much case law out here for
That's true.
RFPs.
Yeah, that's true.
What I will tell you was that we put on notice, we said, for example, we did not know that there was going to be such a cost differential between ACME and the other,
Well, right,
historically,
that's
there
why,
wasn't.
that's why if you're confronted with that situation, it's an RFP, you rebid it, you know?
Well, respectfully, I don't think that we had to rebid it. We put them on notice, we did do a points to percentage ratio. The RFP also instructed
Where are you getting that
ACME
10%? Are you, when you say we couldn't do it the way we had intended to do it? Because once we see the costs, now we can't apply the formula that we had originally listed, which makes me think that it really is a firm formula, not one of these, it's just an example formula. But where do you get that 10%? Is that because you mentioned 10%? Because it doesn't read the way you're suggesting.
In the RFP, it said example.
Right.
I think it was 2 points per 10% was in the formula. Now, I would also say.
Well,
is
what it
that-
says is if the total cost between the lowest offer and the next lowest offer is 10%, then the offeror 2 will have 2 points deducted from the maximum score of 20. You're using nice, simple numbers to explain perhaps a more complicated formula. But the point of the formula is on percentage to points. It doesn't have to be 10% to do percentage to points. That's why I'm not understanding your argument about the 10, because there wasn't 10%, we couldn't use this formula. It's a percentage to points, it's a ratio. You don't have
Right,
to
and-
reach 10% to do that.
But that's what we did. We did a points to percentage ratio. And I would submit that, setting up standardizations and making sure that
Well, I'm
cost
sorry,
has to be
how is it a
certain
percentage to
formula.
points? Walk that one for me.
We did 2 points for every 4% difference in the price.
Well, that's not what percentage to points ratio means. I mean, you've kind of picked a number out of the blue, but anyone who would read percentage to points, you're talking about, right, the ratio in differential between one offer and the other, and how that affects the point score. So if I'm double, I'm going to be hit at 50% of that on my point score,
The way that
or 100%, whatever the mathematician
Yes,
gods
yes.
tell us it
The
is.
way that they did it was the percentage in the amount of money then equaled, if you were at 4 points, it'd be 2. If you were at 8%, then it would be 4
Does that
points.
jive with the numbers? Is that certain that that's exactly what was done throughout?
That is what I was told that the committee had done, and that's what.
And you
the
check the
affidavit-
numbers jive?
Yes, they do.
You see the
I would-
problem, though, in 104B, where it talks about guarding against favoritism, extravagance, fraud, or other corruption. I'm not saying anybody did anything wrong, all right? Let's leave that aside right now. But you received the bids from 3 different parties. You have all of them in front of you. And all of them put in a bid based on a formula that you put in there. Once you have them all, you say, I don't like the way this formula works. I'm going to use a new formula after you look at all their numbers and decide. And that affects who gets it. So simply by changing the formula, you change who gets the bid, or whether or not it's rebid. And that's done after you've had a chance to look at them all and compare them. How is that not an invitation to, at the most, some form of favoritism.
Well, it's certainly not favoritism, because in here, even.
You
even
understand
taking-
what I'm saying, though?
I-
You open up all the bids and say, I've decided I don't like the formula I told everybody to use, I'm going to use a new formula now.
Even if I were to take the formula, the one that a petitioner has suggested,
Mm-hmm.
at the end of the day, his price was so much greater than the other one.
I totally understand
And-
that. I totally understand that. What I don't understand is why, Judge Pickett up for the time constraints you would have, which I think are that's a reasonable argument, but why you just didn't simply rebid this, once you saw that your formula wasn't working for you. I could understand it not working, that happens, but I just don't understand why you would look at everybody's numbers and then adjust the formula to get the results you wanted.
It wasn't that we wanted the result, that, we wanted one over another. Even taking ACME's
How are we to
argument,
know
you
that?
can see that
How-
they
how
would
are
have
we-
still
let me-
not been the
excuse me,
highest bidder.
Excuse me.
Yes.
How are we to know that? Given that you didn't use it, how are we to know that you weren't just trying to get the one you wanted?
Because there is no allegations of fraud, and that's petitioner's burden to prove.
There might not be a specific allegation for it, but tell me how the process that was used here heightens the confidence of the people in your community that the government procurement process is regular, real, and honest, based on what we're hearing here today.
The process itself was in total adherence with 104B and our procurement policy, which mimics 104B. All the criteria, the three companies themselves.
No, all
worked
all
with
of
the
that's clear. I don't want, I know you're trying to answer the Chief Judge's question, but I have this, let me ask it a different way. Why change it? You're saying if we hadn't changed it, our decision would have been the same. So you could have not changed it, done what you did, and nobody'd be here. You changed it, and everybody's saying, what's this all about? And you say, well, it doesn't make any difference. We just decided to change it. Well, you had to have a reason.
The reason that, I was not part of the committee, however, the reason that the committee had said was that they could not find, they thought it was a 2 points to 10% difference in price.
I understand all that.
And
I think-
that's why they changed the
I
formula.
think we understand the math.
Correct.
But if you say the math means these people win, we're going to change it so these people win, and the same people win, why change it?
I don't, even if I don't know why they changed it. They changed it because of the math. That's what I was told. At the end of the day, ACME still would not have been able to be, probably would
Right.
not have been awarded the contract, because 104 requires quality services at the lowest cost. If we were to choose ACME, we would have to have a justification, a written justification. Now, if you look at the other criteria, they were all comparable services. So there could be no written justification for the county to say, we're going to spend an additional $1.6 million annually for another company.
So you didn't have to change the formula.
The facts are the facts. We did change the formula, but even at the end of the day, that formula, we gave notice to it. It was a percentage to points ratio. The RFP told them to put their best price forward. Even if we were to concede his argument, which I'm not saying that I'm conceding his argument, he still was not the highest scoring proposer. He was still behind VW, he was, I think, over VW and 1 point behind quality, so he still was not the highest proposer. And as Your Honor pointed out, we didn't have to give to the highest scoring proposer, nothing in 104B
Can I go back to
requires
that? Because it looks like you're reserving the right to ignore all your criteria, right? The county reserves the right. Judge Abdus-Salam already read it, I won't repeat it, but it looks to me like you write this criteria, and then at the end you say, and by the way, we don't have to follow it anyway, which is one way of looking at the case. But you also say reserves the right to accept other than the lowest, price offer, which seems to me to already embed in the RFP something that's counter to the goals of 104B. So I'm a little confused about how you consider this a lawful right of retention.
I'm not sure if I understand your question, Your Honor.
Okay, well, let's start with the first part. This looks to me like you're reserving the right not to follow your criteria. Do you read it that way, or
I
do
do
you
not
understand
read
it
it
a
that
different way?
I do not read it that way. I think it's a waiver of any informality. So if
It doesn't say that. I mean, it does say waive any informality, but it says a bunch of other stuff.
Correct, but I did not think
How is
that it's a-
accepting other than the lowest price offer a waiver of an informality? Sounds like the essence of this process.
I don't think that they are allowed to, I don't think they're allowed to waive their own criteria. They have to have you have to have a basis for an award. You have to have a reason why you pick somebody. Whether or not you waive an informality versus the audited statements, the unaudited statements, that would be an informality. But you have to have some criteria.
Thank you, Ms. Pierce.
Thank you very much, Your Honor.
Counsel?
I don't agree that 104B requires that the award be given to the lowest cost proposer. If we're only interested in cost, then you put the contract out under a bid, not under an RFP. The purpose of an RFP is to relieve the municipality of slavishly awarding the contract at lowest cost.
All right, they could look at one of you, and regardless of the price, say you've got a reputation for not having safe buses, that that they're not as clean, or that you're not as efficient, or you're not on time. And that's not in the bid. That's just, they sit around and decide this and say, we've had a bad experience with bus company A, so we're going to go with B.
In a bid, if you don't like the company, you have to disqualify them as being a not responsible bidder, which is a much higher threshold than the performance categories we have in RFPs. So that's why RFPs are important, that's why they're used, that's why it's such an important case as for this court to decide whether in an RFP, a municipality can just award it to whoever they want.
The only thing is, though, it seems that their strongest point is the point about the reservation.
Well, the reservation language is, award of any contract shall be made to the responsible offeror whose proposal is determined in the best interests of the county. The question is, are you giving them the unlimited subjective determination to say, notwithstanding 10 categories, one of which was cost, notwithstanding who's the highest winner under the formula we set up, based upon the cost, we think it's in the best interest.
But is there any way you would have won this contract?
Yes, absolutely.
You cost more.
We were 1 point, if we're given the correct number of points.
Points.
We're given the correct number.
What was the cash?
The cash was $1.6 million.
That's a lot of money.
Of course it is.
All right,
And they
so-
should have put it back out.
Well, no, so they can just say, we're taking to somebody that's lower. We're not, why put it back out so you can bid 1.2?
Well, Your Honor, that's my position, is they just can't do that, because that opens the door to lawless conduct. In the procurement area, it's in the paper, it's
In
certainly.
bidding, that makes sense.
Certainly in
RFPs, it
Newsday
doesn't.
today with what's going on in Nassau County, the
Can
procurement
we
is.
get away from Nassau
big ups-
County for a second?
Of course, Your
And just
Honor.
go back to the 20 points for the cost category?
Yes.
They kept their categories. This category is worth 20 points. And again, looking at it as we're reviewing this arbitrary and capricious, rational basis, what they say is, we got these bids. They are so different in price, 1.6 million, let's say, that our formula doesn't give us enough. If you're making them go by the points, to differentiate that 20 points, which is a fair chunk of the analysis, based on a $1.6 million difference. So we adjusted it. It's still 20 points, just the ratios are different.
But they changed the formula, Your Honor.
They changed the formula within the 20-point
Yes, but they changed the formula.
Because, again, we're not looking at, is this formula better than this formula, better for you, better for someone? We're looking at, do they have a rational basis? Was it arbitrary and capricious? And they're saying, it's 20 points, this is the way we looked at it, we saw this big differential in your bids, and we wanted that 20 points to make more of a difference, since you say they're bound by the point total, and then it did.
Then cancel the RFP and do it
And if
again.
Then they
do that
changed
again.
that category, and they rebid it, and it's, you rebid this, you changed that category, and you changed your formula because you didn't want us to get the bid, and we're here again.
Not so, Your Honor, because the courts protect municipalities from that. This is, you can't tell the world what your criteria are going to be, and then you open up the submissions and you don't like the result, so you award it to somebody who's the loser under the criteria that you
What you're
set.
saying is that the rationality of their change is irrelevant.
It's
because
irrelevant.
the change is not allowed, period.
It is arbitrary and capricious, it is irrational, it is a violation of lawful procedure when government doesn't follow its own rules, and it's a hugely important issue in the procurement area.
Could they change it if they rejected all the bids and started anew? Could they change the formula then?
Of course they could.
They could.
They could have
Okay.
changed the formula.
And if they decided not to, under this practical thing that you're suggesting, that they just rebid the whole thing or resubmit the RFP, then do you know, it's still a sealed bid, so you have to, on the cost, so you still have to do some guessing, even though your client
Yes.
has been willing to
Yes.
sharpen
Still a
his
sealed
pencils,
bid.
as you say.
But this-
You're still guessing.
Yes.
But do you know that you were 1.6 million more than the other bidder?
Well, the answer to that is
Consider-
interesting. You would only know if you filed a FOIL request. And they don't have to respond to a FOIL request where they have an active RFP out because it would interfere with the submissions. So you wouldn't know.
Thank you, counsel.
Thank you, Your Honor.